As you were politically humiliated. The entire government was humiliated, particularly your Prime Minister, Justin Trudeau, that you illegally invoked the Emergencies Act. That's why you received your marching orders, probably from the Prime Minister, if not from the PMO, to publicly state your intentions to appeal.
Now, my question to you is, have you actually found and read the infamous broader interpretation? Yes or no?
So what, were you inspired by North Korea for this?
No.
I'm not going to respond to that type of question, Madam Chair.
This Guy's Garage. Like and subscribe.
Thank you, Chair. Good evening, ministers and supporting cast. Thank you for your attendance tonight. It's been a long time coming to get both of you here and your supporting entourage, and we're very grateful. So I want to start off by just opining that it's of no surprise to me, and I'm sure many members on this committee, that both ministers doubled down literally on the same talking points that we've heard from this Liberal government throughout the last 2.5 years, but most importantly after the ruling of Justice Mosley. In my respectful opinion, the federal court ruling provided a massive political humiliation for the Justin Trudeau government. So to you, Minister Virani, were you given a copy of Justice Mosley's decision before it was publicly released at 1:03 p.m.?
I received Justice Mosley's decision when it was a matter of public record.
Thank you. So literally 14 minutes later, Minister Virani, at 1:17, both you and Deputy Prime Minister Freeland issued a release indicating that both of you were planning on appealing. Prior to you making that announcement publicly to Canadians, did you read all 191 pages of Justice Mosley's decision in the span of 14 minutes? Yes or no?
I was assisted by people who were with me, and we jointly reviewed the decision.
And did those people jointly review all 191 pages in 14 minutes?
We made an assessment of the decision, and you've seen the notice of appeal that is a matter of public record. We have tremendous respect for the federal court and for all of the judges therein. Reasonable people can have disagreements about matters of law and mixed matters of law and fact.
Thank you. How long does it take the Justice Department, how long does it normally take the Justice Department to publicly state whether they are going to appeal a court judgment?
I'm not aware of any sort of average in that regard, Mr. Brock. What I would say to you is that it's entirely context specific. It's case-by-case determination.
In my 2.5 years as a parliamentarian, Justice Virani, I have witnessed your government opining on several Supreme Court of Canada rulings and various provincial Court of Appeal rulings, and the talking point has always been we need to review the decision, we need to measure a response, and we will decide in due course whether or not we will launch an appeal. But in this particular case, you clearly didn't read all 191 pages, but it was important to you because you were politically humiliated. The entire government was humiliated, particularly your Prime Minister, Justin Trudeau, that you illegally invoked the Emergencies Act. That's why you received your marching orders, probably from the Prime Minister, if not from the PMO, to publicly state your intentions to appeal. Yes or no?
You're mischaracterizing exactly what I just said to you in my previous response. I said I was ably assisted by others who were there in the room, and we jointly reviewed the decision.
Minister Virani, you were a member of this very committee when on May the 30th, 2022, we ordered the production of the government's legal opinion. That motion passed unanimously. You were in support of that, Minister Virani. Now that you're in a position to do something about it, will you turn over the legal opinion?
The opinions and advice are matters of privilege, which you'll appreciate as a fellow counsel, Mr. Brock. So those are, and I believe you've received a response both from the previous Deputy Minister, Mr. Daig, and also the current Deputy Minister who's sitting beside me to that effect.
I don't appreciate that, Minister Varani. What is the government hiding?
Mr. Brock, we can discuss the importance of solicitor-client privilege, but I'll put it in a pithy manner. It is an important principle that has existed for literally centuries in our joint profession that you and I both...
There's precedent.
If I could
If I interrupt, this is my time. If I can interrupt.
Madam Chair, can I finish my response?
Precedent. Minister
order.
Varani, this is my time.
Point of order.
Excuse me. It's very difficult for the interpreters to interpret when you talk over top of each other. So, Mr. Brock, I'll set you back to 45 seconds. Can you just shorten your question so we can get an answer in?
Mr. Varani, there is ample precedent of numerous governments, including this particular government, to have waived legal opinion, to have waived solicitor-client privilege. If the Prime Minister, to Justice Rouleau, was so serene and confident in his decision to invoke the Emergencies Act in light of Justice Mosley's repudiation of the invocation of that act, what is the government hiding?
Briefly, please, Mr. Brown.
I would say solicitor-client privilege is foundational to the development of legal advice in a candid and frank manner between a solicitor and their client. It is a sacrosanct privilege that has existed for centuries in British common law, and it is one that this government firmly believes in terms of producing.
And you, sir, have the
legal
position
advice.
to waive that privilege.
Thank you. Minister LeBlanc, you opined on the scope of this committee and our responsibilities and the timelines in which, we were we've taken on coming ultimately to hopefully some recommendations in the near future. And yet the Rouleau Commission accorded you 12 months to respond. And that deadline is passed. Why?
Because, and as I said, I will have detailed responses as is appropriate, of course, to the Commission's recommendations. We wanted to, in light of the federal court decision, we wanted to ensure that the government response would take into account the trial division decision. And we wanted to ensure that as we were responding to those recommendations, it would be done in a way that would be consistent with the government's decision also to go to the Federal Court of Appeal on that decision. So, but for that court decision, we would have done it last week or this week. Good news is I'll be happy to do it next week.
And in part of that report, will you provide an explanation for the changing nature of your definition of a threat to security of Canada, as is accorded under Section 2 of the CSIS Act?
And it's an issue that the Commission raised. It's an issue that I know has been discussed at this committee. And our response, as I said, will detail the government's specific response to all of the recommendations of the Rouleau Commission, including his suggestions around legislative change.
Mr. Vigneault, have you undertaken any work at CSIS to provide input or memorandums or any kind of background briefing documents to Cabinet relating to your organization's position as it relates to Section 2 of the CSIS Act in accordance with the parameters set out for a threat to national security?
Madam Chair, we have done work on Section 2. We have been doing work on a different aspect of the CSIS Act for years. And when the government comes up with its decision on the responding to the Rouleau Commission report, we will be able to advise the government and provide our analysis in due course.
Mr. LeBlanc, I would put to you that at this point, we still haven't heard, in my opinion, an adequate explanation from the government on its use of that definition under the Act. And now we're hearing in other bodies that they've expanded the use. They've perhaps provided some editorial expansion on the definition of a threat to national security. But I can share with you that despite all the meetings and all of the witnesses that we've had here, I've yet to hear anybody clearly articulate the government's rationale for changing that definition. Will that be included in the Rouleau Commission report, specifically that point? your report back as
Our response to the
Your
Rural
response,
Commission report,
yes.
yes. Well, again, I know people will be very excited to see the government's response to the Rural Commission, and the good news is it's coming soon. And as I said, we think Justice Rouleau did an important, exhaustive
Mr. LeBlanc,
work.
sir, please. We've been at this for quite some time. I'm asking you a direct question. I'm going to ask for you to provide a direct response.
So I'm not going to tell you what's in the government response to the Rouleau Commission. I'm telling you if
Okay, so, sir, what I'm going to put to you is that this committee has a responsibility. We've heard Mr. Varani and many people come before this committee talking about client solicitor privilege. We had that conversation today at Ethics. We heard him say it was sacrosanct. I would put to you that the powers of Parliament supersede that in our ability to send for documents and get information. So if it's your position that you're not willing to testify on a very basic answer tonight, are you then prepared to come back to this committee in 2 weeks? And are you then prepared to be a part of a process that prolongs this committee rather than just answering a very straightforward question, sir?
you've asked about 4 or 5 questions.
It's one
and what
question.
You say is a straightforward.
It's one
question.
Let's not dance around
You
it. The
said that I
question's-
wasn't prepared to testify about that tonight. What I said is I wasn't prepared to talk about the government's detailed response to the Rouleau Commission report.
It's not what I asked.
Until we talk about it publicly next week.
What I asked was, will that be included? Will it be included? That specific parameter.
The government will respond to every one of Justice Rouleau's thoughtful recommendations.
Mr. Varani, is it your contention that cabinet confidence is supreme and superior to the Parliament's privileges here as accorded through long jurisprudence within the House of Commons?
I'm glad you raised cabinet confidence because I think it's important to understand, because you have raised this and Monsieur Fortin raised it, but the functioning of a parliament and our system of parliamentary democracy as it's been inherited from the Westminster model includes cabinet confidence. So we're not just talking about solicitor-client privilege materials, we're talking about cabinet confidence, which exists to promote open and candid discussions around the cabinet table in the public interest that will be fearlessly advanced at that table and then defended.
Mr. Varani, as you would have heard in my previous testimony, and we've had these discussions, and you're a very learned lawyer, you're the Attorney General now, that despite that assertion outside and within the courts, inside Parliament, would you not agree that the Constitution states that Parliament has the power to send for people documented information that would supersede this notion of everything being client solicitor privilege?
Mr. Green, your time is up.
There's 10 seconds left, is there not? No?
Not according to mine.
Oh.
But I am next, so Mr. Green, will you take the chair?
Happily.
And Mr. Vrani, I would ask you to take the opportunity to answer his question.
So I agree that Parliament has the power to make the request. I do not agree about it superseding necessarily cabinet confidence. Cabinet confidence is waived very rarely.
Thank you.
Do you have anything to hide?
Plaisir de vous voir, sénateur.
It's a pleasure to see you, Senator. No, I don't. Then why don't you provide us with a legal opinion? Can I answer, Madam Chair? Because it is subject to solicitor-client privilege. Okay, fine. I'm a lawyer. I remember I spent a lot of time studying privilege, but who's it in favor of? The cabinet. The client. So why doesn't cabinet simply revoke that confidentiality? I think you two probably have a lot of power in cabinet. What are you waiting for to provide us with a legal opinion? Mr. Minister, you say Justice Rouleau decided this, decided that. He studied everything, but he did not study the legal opinion. It was refused to him. So there are two things. Either it's legal or it's unlawful. Forgive me, but every time the senator hits the table, it can harm the interpreter's hearing. My apologies. What are you waiting for? If the legal opinion is lawful, then share it with us, and we'll clear it up immediately. Mr. Senator Carignan.
You would appreciate that it is not the contents that we're trying to protect. what is critical in protecting solicitor-client privilege is a relationship that existed, as I mentioned, for hundreds of years between solicitors and their clients, which promotes candor and free and full and fair advice. Understanding that privilege is sacrosanct between that professional and their client. It is important to the functioning of law in this country and in British common law.
Don't talk to me that way. I feel like you are taking me for a fool.
Madam Chair?
Please do, and then Senator
J'en ai des
Carrion.
clients.
So the point
J'en ai eu
is,
des clients. Si le client
I guess
me
I'm not
dit,
able to finish,
si
Madam
le
Chair.
client
Senator
me dit, vous pouvez parler,
Senator
donner
Carrion.
l'opinion juridique.
If a client tells me that they are breaking solicitor-client privilege, then it is broken.
I remember fondly your frequent references to Supreme Court case law at this committee, Monsieur Le Carignan. The Supreme Court in case law has actually attributed this, and I'm reading from a case called McClure, that this ensures vitality of full
I conclude
between those who need legal advice and those who are best able to provide it. The
Point of
resulting
order,
confidential
Chair.
relationship between the solicitor and client is a necessary and essential condition of the effective administration of justice. That's the Cour suprême du Canada.
OK, donc vous la cachez.
I've got a point of order.
Madam Chair, maybe,
Those are your words, sir.
maybe it's a function of people talking over each other, but I know that the interpreters are having a very difficult time translating the exchange. And when they have difficulty, we lose out. Those who
Couldn't
don't
agree with you
understand the
more.
French language, I would have loved to have fully understood what Senator Carignan was putting to this witness, but I wasn't able to.
Okay, so
Translation was not able to keep up.
I totally agree. May I ask all committee members and the witnesses to refrain from speaking over each other, allow the witness to answer, and then ask the question. If you need it shortened, you can indicate that. So, Senator Carignan, you have 1.5 minutes left.
Donc j'en conclus que vous avez quelque chose.
So I can only conclude that you have something to hide.
Have that on the record,
Pouvez-vous
Madam Speaker.
m'expliquer que
Can you say the emergency measures were essential? There's a note here, Jacqueline Bogdan, Vice Secretary, and they sent this to us after we requested this. Daily report, 11th of February, 8 a.m. A few people are on Wellington Street and surrounding streets. February 12th, 8 a.m., 0 to 5 people on Parliament Hill, a small number of people on Wellington and surrounding streets. February 14th, 8:13 a.m., nobody on the Hill, nobody on Wellington or neighboring streets. And then you invoked the Emergencies Act? Madam Chair, I remember Ms. Bogdan. She's a senior official at PCO. I haven't seen the document that Senator Carignan was citing. I was part of the incident response group. There were several officials describing a dynamic situation in several jurisdictions. I'm not sure how many people were on the street corner on Wellington at 8 a.m., but I'm very comfortable with the decision the government made.
The timing of the acceleration of the threat, how was that handled amongst the various players, not only from the federal government, but the provincial governments and the forces on the streets? How was that handled?
So, Madam Chair, perhaps, I don't know if it's the Commissioner or the Director of CSIS, perhaps can add, because they participated in some of those discussions. Certainly Director Vigneault was in his job and was in some of those same meetings as I was at the time, or the Deputy Minister. I know that as a government, we looked at a threat picture across the country based on what we were hearing from law enforcement partners across the country. And as I said, there was, and this was publicly available reporting, an increased risk of sort of a contagion or a spread. That was one of the important factors we considered. But I don't know if the Commissioner or David wanted to add something.
Yeah, Madam Chair, very briefly, Senator Smith, the way that the system worked at that point is very quickly the different levels of law enforcement and intelligence got together through joint teams. We had a team here in Ottawa. There was a team in the province of Ontario as well that was stood up with the OPP. And the purpose was to share in a very dynamic way intelligence and information to understand. So from a CSIS point of view, my people at the table, their job would have been to bring in intelligence about the threat actors that we were concerned with and be able to get information from law enforcement to inform our own investigation. And so that very dynamic process was taking place at the officials levels, law enforcement and intelligence, in Ottawa, but also in the province of Ontario. And that information was then fed up to the incident response group that Minister LeBlanc referred to earlier, so that the cabinet represented by the members at the IRG would receive that information and that advice.
Western Canada, where you had a major dust up west, was that part? They were part of that?
Absolutely. So, for example, at this point, the RCMP, my RCMP colleagues and the Canadian Border Services Agency had people on the ground who would be reporting right away to Ottawa in terms of what was happening. And then, that information is analyzed and then, reported back up. And then, depending on the situation, CBSA or CMP, in some cases, CSIS, would take, specific operational measures to be able to address the situation at the same time as we're providing information and responding to advice requests from the government.
I've been here as well all this time. I've studied as much information as I can at this committee and outside of this committee on the invocation. I still believe more strongly today than I did in 2022 that the circumstances to invoke the act were not met, the threshold was not met, and in fact agree with Justice Mosley on his decision that it was in fact illegal and unconstitutional. That is a binding precedent, unlike Rouleau's particular ruling. Now, the other thing that I think the Canadian public need to understand is Canadians expect their government to follow the law, the rule of law, and not create an interpretation thereof that is convenient for the government to circumvent the existing law. And, Mr. Virani, you had indicated that, there are hundreds of years of precedent for lawyer-client privilege. And, the relationship has lasted hundreds of years. And you know what else has lasted all that time? For Parliament to make laws of the land which govern the people. And by invoking the Emergencies Act, the cabinet gave itself the power to pass criminal laws which Mosley found to be unconstitutional. Now, my question to you is, have you actually found and read the infamous broader interpretation? Yes or no? That the government relied. Have you actually read the legal opinion, the broader interpretation that the government was telling everyone that they relied upon to invoke the Emergencies Act? Yes or no?
Mr. Motz, I'm trying to be helpful, but even answering that question would disclose social-client privilege, which I cannot do here. But what I would say to you is that
let me stop you for a minute. You obviously can you answer me the date stamp that was on that?
Mr. Motz, in terms of solicitor-client privilege,
okay, so you can't. The reason I asked that question,
the questions you're asking me,
yes or no, you've already answered. It was a yes
Motz,
or no.
Remember, excuse me?
Yeah.
Remember, we have interpretation. Please
it was
don't
a
talk
yes or
over.
no question.
Please don't talk over each other.
Mr. Virani, I don't believe for a second that the broader interpretation even existed when the Emergencies Act was invoked at the time of the invocation for a number of reasons. And, it wasn't really until just weeks before the Reload Commission was about to begin that we all of a sudden heard about this broader interpretation, that it somehow magically appeared. And it's really quite disturbing that this broader interpretation is there now, and no one's seen it. No one's heard it, apparently. Mosley didn't get an opportunity to have it as part of his disposal, and neither did Justice Rouleau, who indicated that the evidence that he found to support the government's invocation was weak at best. and that anybody else could have come to a completely different conclusion. He was disappointed the government withheld that. So one of the questions that I've had for a long time is, who actually is the client? And you're hiding behind solicitor-client privilege. And why is it so difficult to, is it the government? Is it of Canada? Is it the governor and council? Is it the prime minister? Is it the attorney general? In your opinion, who is the actual client in solicitor-client privilege in this particular case?
In this particular case, the client is the government of Canada, and what I would say to you is
Who
the
is the
same thing I
people of
said.
Canada?
It's the same thing I said to Senator Carignan, which is that there's nothing to hide, but there's everything to protect. And what my job is to protect basic principles about the administration of justice. Solicitor-client privilege is fundamental to that system, as the Supreme Court has opined.
Well, we're just getting wound up.
I know.
Mr. Varani, you identified that the government of Canada is the client. Who's the solicitor?
I'm the solicitor as well as the people that assist me.
And
or my office.
And you're also part of government.
That is correct.
You're in cabinet.
That is correct.
Yes, so you're both the client and the solicitor.
I wear different hats at different times
Sure.
in this context.
I remember the S&C, the details of the S&C Lavalin affair well when a previous Attorney General made a very clear distinction that there is some significant challenges about being both the client and the solicitor, and yet your testimony here today is that the sacrosanct feature is to protect the relationship, but the government has a long history of waiving competent confidence. So how do you defend that when most, as my understanding of the legislation that provided you with public interest immunity, weighed the balance of the protection of government information with the public interest? Having spent so much time on this committee, would you not agree that it is within the public interest to provide the most amount and the highest level of transparency and accountability to the Canadian public, given the fact that the purpose of us being here is on one of the most extreme points of legislation, namely the Emergency Act, sir? So being both the client and the solicitor, please explain to me and the public how you justify not providing basic information in the general public interest.
So let me clarify something. I think it's important for Canadians watching to understand that the Minister of Justice constantly provides, as the Chief Law Officer of the Crown, advice to Cabinet and to government.
I didn't ask for that clarification, and the round is mine.
That is my job.
I need you to actually answer the question I put to you.
I'm trying to answer the question, Mr.
We don't
Green.
need a history lesson. I want you to answer the question I put to you.
So it is possible for the Minister of Justice to wear different hats around the Cabinet table. That's the first point. The second point, sir, is that I don't agree with your assertion that Cabinet confidence is regularly waived. I know of very few instances, actually, that it has ever been waived. And in terms of ensuring transparency with this process, I'm trying to provide you with as forthcoming information as possible. You've been provided with what is effectively similar to a charter statement. You've been provided with information from the previous Deputy Minister, François Dague. We are assisting you as best as possible without
That suffices.
reaching the important
With my 20
components of
seconds
Solicitor
left,
Cabinet,
I would
Solicitor
put to you
Client
that the
privilege.
average person watching who heard you talk about the sacrosanct relationship with yourself will not be willing to accept the answers that you've provided here today. And ultimately, I don't think further the public interest of the investigation that we're trying to do. Thank you.
Senator Harder.
Madam Chair, can I respond to that?
My time's up.
Time is up. Senator Harder.
Minister, let me donate the first part of my time to your response.
I think the Canadians that are watching right now in response to Mr. Green would appreciate that the Chief Law Officer of the Crown takes very seriously the issue of how the administration of justice unfolds in this country, and protecting solicitor-client privilege is something that I'm duty-bound to do, not just as Minister, not just as Attorney General,
Thank you. Let
but in
me
terms of
ask
my
my
oath to the
question
bar.
My question is for Director Viano. When you were here last, you talked about the emerging threats and the changing threat profile. Could you comment further in terms of the elapsing 2 years as to whether the trends that you forecast are altering, and if so, in what way? And what should we as parliamentarians be concerned about in the area of public safety and security and racially motivated and religiously sponsored terrorism?
Thank you, Madam Chair. Senator Arthur, unfortunately, my answer will not be a very positive one. What we have seen in the last 2 years is an increase in violent extremism in our country, both motivated by ideology but also by religious motives. And that has accelerated also since October the 7th, the attack by Hamas on Israel. So we have, unfortunately, here in Ottawa, we've had, a terrorist plot that was thwarted because of the work of CSIS, the RCMP. And so from an extremism point of view, we have seen a rise in religiously motivated violent extremism. We also have seen what was the concern during the convoy, the ideological motivation continue to increase, both in terms of its people who are motivated against, so anti-government motivation. We have seen an increase in that. We have seen people who have continued to engage in planning, in prepping for activities, doing military-type
and
drills.
Do you have the adequate authority and resources to respond to that increased activity?
So we have been working with the government and with Minister LeBlanc to provide advice on potential changes that would be required. And I'm not sure if the minister has views on that for the committee tonight, but there is indeed, a lot of work being done to make sure that we all have the right tools at our disposal. And I would just maybe add, in terms of foreign interference, we have continued to see an increase, and there is a commission of inquiry underway that will hopefully provide Canadians and House of Commons and the Senate, with some perspective on how the threat has continued to evolve and essentially make it more difficult for Canadians here.
And Minister LeBlanc, will that be part of your announcements of next week?
Through you, Madam Chair, Senator Hart, no. The specific resourcing of CSIS, for example, or some of the statutes, particularly the CSIS Act that's 40 years old, as some parliamentarians know as well as I do, is legislation that we think might be modernized to reflect the threat profile the director just referred to. As you may know, we announced consultations in the fall around looking at modernizing the CSIS Act, so that will be a separate parliamentary process, obviously, with the Senate and the House of Commons. But we as a government, and based on the advice of the Commissioner and the Director, recognize that the threat picture and the threat landscape is evolving in a negative way, as the Director said, and our job as a government is to make sure that the security services have all of the resources, including legislative and regulatory authorities, to do the work that we ask of them.
I'm trying to imagine in what kind of free and democratic society in the world it is possible for the authorities to seize bank accounts for protesters.
There was a freezing for a temporary period of time in the assets that were then unfrozen.
OK. Donc, à quel endroit on freeze ou on gèle des...
So where are bank accounts frozen, which means that people can't actually spend the money in their bank accounts? So you're removing their goods for a period of time. Where is this done with no judicial authorization for the sole reason that those individuals are protesting in the streets?
I think, Senator Kerry, after 2 years on this committee, I think you probably know the answer to your own question, that we were dealing with a situation where there were unlawful and illegal activities, where people were being financed, including from Bitcoin sources, et cetera, including from foreign sources. So the idea was to destabilize the illegal blockade by cutting off its finances, which is effectively exactly what happened.
OK, donc c'était ça l'objectif. Comme le ministre...
So that was the goal, as Minister Lametti told us. It was to pull the rug out from under them.
Those were not my words.
OK. Donc le but, c'était de faire une pression économique, empêcher de faire...
So the goal was to put economic pressure on these people to stop them from buying groceries, paying into their health insurance, and get them out of the streets?
Not the characterization that I would put on it. The objective was to ensure that those who were funding the continued illegal blockade of this and other cities were no longer able to do so.
OK. Donc, vous n'avez pas répondu à ma question.
So you didn't answer my first question. In which other democratic country is it possible to do that?
Democratically passed legislation in this country pursuant to the Emergencies Act in Canada.
OK, donc vous avez fait le droit, là. Vous vous êtes inspiré de la Corée du Nord?
So what, were you inspired by North Korea for this?
No.
I'm not going to respond to that type of question, Madam Chair.
Non, mais de quel pays vous êtes inspiré?
No, but where did you get your inspiration? Mr. Carignan.
Need to consult the statutes that are in the statutes of Canada, the revised statutes of Canada. I'm sure you're perfectly aware that a bill called the Emergencies Act was passed by the Conservative government around 1987, 1988. In fact, I remember sitting on this committee with you when Perrin Beatty testified to the passage of that very law. It is pursuant to that law in this country that we enacted the declaration.
Senator Carignan, your time is up.